So, sir, for the beginning, I want to ask you what are the new rules for redevelopment under Maharera?
See, in Maharera, for the existing members, there is no remedy. It is only they will have to approach the consumer court or the high court for specific performance. And now, even the pecuniary jurisdiction has changed. So, up to 10 crores, you will have to go to the city civil court or civil court of your district. And if it is about 10 crores, then you can approach the high court for the existing member. The RERA clearly says only allottees have the remedy in RERA and not the existing members. So existing members, RERA is not considering them as an allottee.
Okay, sir. And sir, how many members are required to go ahead with redevelopment?
See, it is a simple majority. In Maharashtra, it is a simple majority. If it is even 51% agrees to go for redevelopment, they can go for the redevelopment.
Okay. So the next question is, what if one member does not consent to redevelopment? So can the society go ahead with the redevelopment?
No, the recent judgment of the Bombay High Court clearly says that minority members cannot stall the redevelopment project. Only if it is there is a genuine reason, like the development agreement has a one-sided clause, or which is going to affect the interests of all the members. And if it is genuine, then only you can approach the court. Otherwise, the minority members do not have say in the redevelopment project until and unless it's a question of law and protection of the interest, where we can say that this document itself, the development agreement, is one-sided and it doesn't protect the interest. So this so and so clauses have to be changed. And I'm not against the redevelopment agreement, but I am against the clauses of that development agreement or the PAAA.
Okay, sir.
So, if in
Yeah,
case the
that is,
probate is not done or the title is defective, the title is not duly being transferred to the party,
yeah.
can it go through redevelopment and how?
See, for one member, you cannot stall the redevelopment project, right? They'll have to go for an appropriate remedy in the High Court and register that property, get the property, and they will become the owner of the newly developed
Yeah,
flat. But
yeah, but
since one
can the
member is not
redevelopment
having
occur?
his, since one member is not having his title clear, it doesn't mean that the whole process of the redevelopment will be stalled by one member.
But if major people or the people have not duly transferred their property, some are just as nominees, the society has not duly
That's
transferred
why
their
I
property.
told you that if the majority people have a problem, then the redevelopment process cannot take place. It cannot be kick-started. So the majority of the people first will have to come together and resolve their issues, right? If the majority decides to go with the redevelopment, then minority members do not have any say to stop that redevelopment process. Now, what you are talking about is the title. So for it will be depend on case to case. Now it is a very general thing why it is been not transferred. So you will have to look out into each and every case and give a remedy or give a solution to that particular member or that particular flat to whom it belongs.
But can the process of redevelopment, the PAAA agreements, everything get duly
Now
registered with the defective
tell
title?
me how the PAAA will take place. PAAA is permanent alternate accommodation agreement. If the title is not
Hmm.
going clear, then who is going to sign that agreement?
Okay.
Even in
Okay.
the development agreement, every member's signature is required.
Sure. Thank you.
So in this case, if a nominee is appointed, can the nominee assent to redevelopment in the event of death of a member?
See, nominee will be treated as the trustee of that property till the legal heirs are established. So he can act as a trustee, but he cannot become the owner of that unit.
Okay, so what happens to the redevelopment process then?
Redevelopment process can carry on. It
Okay.
cannot be stalled by one or two people who does that they are been nominated as a nominee, but they are legal has been not yes established. So the redevelopment process can take place. Only the PAAA will be signed when the legal heads are established as per the law.
Okay, sir. So in the chat, a participant is asking, extra area के लिए क्या provisions है?
See, for extra area, the government is giving 35% free fungible FSI, right? So there is no premium charge. So you are automatically, you get 35% extra. Only the builder has to do the construction cost. So if you stick that this is the norm, that I get 35% free fungible FSI and I'm entitled to it without any cost. But in some cases, they give 25% because the project is not viable. And in some cases, they give more than 35%, say from Bandra onwards, because the prices of that area, that locality is high, right? So construction cost is almost going to be same. It is hardly, if it is 3,000 to 4,000, suppose in Bandra, it will be 5,000 rupees per square. But the selling price, what we get in Andheri, Goregaon, Jogeshwari, and Bandra, they are going to differ. In Andheri, it is around 25, 30,000. In Bandra, it is somewhere rupees 1 lakh rupees per square feet. So the builder can afford to give you more area if your property is in prime location. So it all depends upon the feasibility report. I tell you first, when you before you jump into the redevelopment, there are three things which has to be seen before you, prerequisite, that the land is conveyed in the name of the society. The land is transferred. Second is effect of that conveyance has been reflected in the property card. So even the property card has the name of the society as an owner. And the third is an independent architect's feasibility report, not the PMC. Because people get carried away कि हमने PMC से कराया. They may sometimes they make some mistake. So you have to protect your interests, take a feasibility report, and understand what is the potential of your flat. So and then you can appoint a PMC because you know what lies or what is your real value, what is your worth. PMC may not always give you your worth because there are various other factors which are affecting the sensitivity of the PMCs.
Okay, sir. So the same participant wants to know corpus fund क्या होता है और corpus fund का amount कैसे determine होता है?
Yes, it's a very nice question. There is no formula for the corpus fund. The corpus fund इसके लिए दिया जाता है so that when you go to a new flat, your maintenance is going to increase. So you have some fund which will take care of the increase of the maintenance. Now the corpus fund is decided on the location and the premium which the builder is going to sell the flat. If it is in Bandra, you will get more corpus fund. If it is in Andheri, you will get less corpus fund. If it is in Daisar, you will get very much lesser this thing, corpus fund. Because it is the revenue which is being generated by selling the property. Now, you try to understand. First is he's going to demolish your building and then he will pay the premium. And I insist that on the day one, once the IOD is obtained and the building is demolished, he has to obtain the full CC from first floor to the top floor. Maybe it is 10th floor, 20th floor, 30th floor, I don't know, whatever it is, but to the top floor, he has to obtain the full CC. So that is one cost, premium cost. Second is the construction cost of the rehab component plus 35% plus here and there, it depends upon the location, plus the construction cost of the sale component, plus the cost of the rent which he will give you, which you will be staying for almost 3 to 4 years outside your existing flat. All that is counted, and whatever is left over is the profit. From that profit, builder will decide that I am going to give such much portion of the corpus fund. So that corpus fund, you will get a right figure if you appoint an independent architect to come out with a feasibility report where he will say this is your cost of construction, this is the rent which is we are assuming, and this is the corpus fund which we are assuming, and this is the sale component which we'll give to the builder, which he will sell and make profit and do the construction of the rehab component as well as the sale component. So that gives you a clear picture. So for that, first three things which you have to note before going into the redevelopment is the conveyance is to be in the name of the society. The name of the society is there in the property card and a feasibility report. And then you decide which PMCI should appoint and an advocate. The advocate fees are to be paid by the society. Don't keep it. Don't become a miser and say, "नहीं वो builder खर्चा उठाएगा." So if builder is going to pay to the legal advisor, to whom he is going to favor, builder or the member. Please type so that I can understand. If builder is paying the legal fees or the fees to the legal advisor, to whom he is going to be more faithful or whose interest he is going to take care of the builder or of the member. So it is always advisable that society should have their own independent legal advisor whom they are paying fees and he is answerable to the society and not to the builder. Next question.
Okay.
Yeah, good afternoon, sir. I'm
Good
Aarti.
afternoon.
Sir, you have mentioned three clauses before going in for redevelopment, that is property card and getting the conveyance and then property card and then the feasibility report by an independent architect, right, sir?
Yeah.
Now, if the society committee doesn't agree for an independent architect because they don't want to make the payment, and they want to go with the PMC, can this become a clause for not giving your approval for the redevelopment consent?
See, it is your own interest to have an independent architect to get the feasibility report.
I agree, sir. We
So,
have put across this 10,000 times, but they
yeah.
don't want to do it. They stamp duty also. They say कि builder stamp duty भरेगा सब flat की और PMC सारा
Stamp,
काम करके
see,
देगी.
stamp duty to bharega, that is not an issue. Stamp duty builder bharega. It is there in the agreement. But it doesn't say that the agreement should not be vetted by your this thing.
हाँ, so I want to know कि ये चीजों की अग्री नहीं कर रहे तो जब आपने बोला कि कंसेंट मेजोरिटी से होती है and if I as a member do not give my consent because a basic thing है कि they are not ready
No,
for
you don't do that. Don't give a consent. You appoint an advocate and bring out what are the
oh,
shortfalling of that agreement and tell that I am giving the consent provided these one-sided clauses are rectified.
and who will bear the cost of me appointing the advocate because the society is not functioning
So
properly?
you will have to bear it. Huh?
Okay. And secondly, sir, what is the importance of redevelopment committee, even if it is appointed in AGM by the society? What are the powers and what is the importance
No
independent
power.
of managing
The redevelopment committee doesn't have any power. They will do the homework. They will supervise the overall redevelopment process. If there is any
okay.
shortcoming, see, in the legal committee, you should have one person who has a legal background and one person who knows about the construction or one person who is a structural engineer or an architect. So they know that how it is to be done and your interests are protected.
And last question, sir, when we get a conveyance order through consumer code, does the society get any compensation from the builder when they get the conveyance order through the consumer code?
Yeah.
Monetary compensation?
See, it all depends upon the case to case. There is no fixed formula. I can say, and then you add 2 plus 2 is 4. For approaching the consumer court, there are many other things which has to be looked upon. The pecuniary jurisdiction and what is, there are two things for which a home existing member can go to the consumer court is for unfair trade practice and deficiency of service.
Thank you, sir. You know me, I'm Aarti Agarwal Gupta. I've got in touch with you through Kamal Gasiwala. No, thank you, sir, and thanks for the advice because I'm facing this issue. So that is the reason. And so last question, sir. Before giving consent, can I ask the builder to look into the matters to protect the trees and the animals on the society premises that they
No, no,
shouldn't be harmed and a shelter?
no. Can you repeat that question again?
Sir, before giving my consent for any redevelopment activity, can I
Yeah.
put forward to the and the builder that the trees and the community animals like cats and dogs should not be harmed because they are protected by laws and they should be adequately protected and a shelter should be created because they were also the inhabitants of this place.
You can do that. There is no harm. But for that, you cannot stop, means for not giving the consent because of the cats and dogs issue will not be this thing. You say that I'm giving the consent provided that these things are taken care of.
Okay, got it. This is the way I should word it.
Yeah.
Thank you, sir.
So 3 questions. Title which is not duly transferred, would that hinder the conveyance process?
Conveyance process.
Developer,
How are
yeah,
you going?
I'll tell you the facts of the matter, sir. Developer sold to property to A. A sold it to B and C, which was through an unsigned agreement. And so that was, way back. So we are not able to take it in for amnesty. And the position is taken by C through a gift agreement, which was not duly registered, duly signed, just endorsed somehow as an error in the. Now, would this title affect the conveyance process, or I may have to complete something about it and LOA till the time the conveyance is
No,
done?
you can go with the conveyance process. That is not an issue. How you are going? You are going for a deemed conveyance or you are going a conveyance to
Deemed
the
conveyance,
consumer?
deemed conveyance.
So deemed conveyance, then that can be done. But only thing is that whatever the stamp duty will be calculated by the adjudicating officer, that is the sub registrar of stamps, that member has to pay.
Okay. Got it. 20. So question number 2, the rent is paid by the developer as post-dated checks in order to, or is it one shot, or is it every monthly or quarterly basis?
See, nowadays I'm getting, for the first 1 year, the builder is paying upfront.
Okay.
For the second and third year, they give a post-dated checks.
Okay. Okay. Any bank guarantees in these systems?
There
To some-
is a bank guarantee, but people nowadays what they say is the builder that since the RERA has come, we have to be transparent, we upload everything, and there is no question of giving you bank guarantee, but you can still work out that in the sale component, not on the top floor, but just the flats about the redevelopment this thing. You should keep adequate flats lean with the society and then release subsequently as the work progress till the final occupation certificate is not obtained.
But that will be lean, but not a bank guarantee.
No, not a visa bank, but it serves the same purpose.
Okay. Okay.
See, now
Okay.
what I tell you is, see, why I am insisting on the three things is first, get the conveyance in the favor of the society.
Right,
Second, transfer the name in the property card that it should be named in the society.
Right, sir.
And third is the feasibility report. So once you know that in the feasibility report also that from ground floor to top floor, how much premium has to be paid. So you ask for the builder that you will have to pay the premium of all the floors, which is going to construct at one go only. So the liability on the home buyer, on the existing member becomes very less. Then only the construction cost is left, right? What is the construction cost? Between 3,000 to 5,000, depending upon the amenities or depending upon the location.
Right.
So that is easily doable thing. So once the builder pays the complete payment for the CC from first floor, from the ground to the top floor, then you are being taken care of everything. Now, initially, what was happening is builder used to take part CC. He will take CC for the clean, then he will take the CC for the first slab, then the second slab. And in between, he is not able to sell the flat. So he is not able to construct because he has to pay the premium to the corporation or to the MADA or to the SRA. And then only they will give the permission. Now you can construct the another floor. So when you are having the full CC to be paid at the time of immediately after the IOD, so the bank guarantees are not required, and plus you will have the
Okay.
lien on the flat.
Okay. Got it, sir. Okay. Thank you, sir.
Okay, sir, on the chat box, there's a question from the side of member. What documents need to be cleared
What documents regarding what you want?
for the process of redevelopment? The
See, for
participant
the
asking this query, you can ask this question directly. Maybe that will be better.
yeah, if you can ask me directly, so I can ask him what he means by the documents.
Okay. So the next question is, what are the provisions for self redevelopment, and if there's any material available online that you can recommend?
See, there are many videos which I have made on self-redevelopment. You can refer that. And there are many incentives for the self-redevelopment. The premiums are getting reduced if you go for a self-redevelopment. The interest on the loan if you are going to get, that is also being reduced. And secondly, instead of cutting our hands and giving it to the developer, in which you have no control, and if developer diverts the fund, no matter where is there, where it says that 70% of the fund which they receive on this project has to be utilized in this project, but they have various ways. In India, we say that they have jugaad, and the fund is diverted and the building is not constructed. Whereas as on today, there are few redevelopment projects which have been successfully completed, but I have not come across any single project where the self-redevelopment project is stalled. So there are many benefits. You will get more area, you will get more corpus fund, and the profit which the builder is going to take, that is going to be there among the members. So that is the biggest benefit. Only that you are, what you say is, you are ready to trust the outsider that the builder, but you are not ready to trust your members who are with whom you are staying for the last 30, 40 years for the self-redevelopment. So you will have to develop that trust. There is a trust deficit that ये MC में है तो ये कुछ ना कुछ कर रहा है उसके लिए रीडेवलपमेंट में से तो वो माइंडसेट से आपको बाहर आना है मैं नहीं बोलता हूँ all the managing committee members are good. There may be a few instances where some of the managing committee member will have their personal agenda or interest to promote the means the redevelopment with the builder. But in the self redevelopment, it is very safe and you are in control of each and everything at each and every stage.
Okay. The next question is, suppose there are multiple societies comprising of 8 entities and more than 10,000 square feet area. So do they need to get into amalgamation or federation of societies, or the
Yeah,
individual
so
societies will suffice?
no. There are many ways of doing it. You can go for a cluster development also. You can form a federation and then go for a cluster development. So in cluster development, you get more additional FSI, more open space, and there are much bigger benefits than you would ever imagine for going for a redevelopment of a single society. It can be very beautifully planned, and you can get more areas, more corpus fund. And I will prefer to get more areas than harping upon the corpus fund with the builder, because property prices are going to increase day by day. That is when the land which is available as on today is very limited. You cannot increase the area of the land, right? Why people are going, or why the redevelopment is going? Because there is no open land available in Mumbai or in Pune. So the old buildings have to be demolished, and there is a way for redevelopment. Now, why this amnesty scheme has come? Because all the redevelopment projects which were taken by the builders were stalled because of the stamp duty being not paid and the conveyance being not happened because of the stamp duty. So government came out with a very beautiful scheme, which is, up to 1 lakh. The 31st January's date is gone, but up to 1 lakh, there was no stamp duty to be paid, and up to 1 lakh, there was no penalty. So it was a Diwali's and Christmas bumper dhamaka bonus, which was given to government to us. But why it was given? So that the redevelopment process can kickstart. And once the redevelopment project kickstarts, then it is helping the economy. It is creating more jobs. And just imagine, from excavation till the building is finished, that particular building is feeding another 200 industries, right from tiles to aluminum windows, glass, furnitures, you name it, and it is there. Switches, like everything you need it, the plumbing pipes, the accessories. So all these industries, they get new orders. So all the government will push that the redevelopment process has to be kickstart, so that the government also gets the revenue in amount of premium giving to the builder, right? So builder is not getting the premium free. Some relaxation is there, but the crores and crores of rupees going as a premium to the treasury of the Maharashtra government. So this is a very right step which the government has taken.
Yes, sir.
So I have two questions. One is that my society, my society does not have any additional FSI. So what the committee is deciding is to buy TDR and then do redevelopment. Okay, and there is zero additional FSI. Second thing, to give a little background of the same society, it's a society land given by MADA, where it's on a 99-year lease to the society. Okay. And so I think conveyance does not make sense, because the society will not become owner of the land. Also, the MADA will be involved. Even if you get the conveyance, you have to go back to MADA to get all permissions, even to decide on the builder. Or if you want to do self redevelopment, MADA's approval will be taken, and they will also reserve some few flats, say 6, 7 flats or whatever it is, so that they can sell and make money out of it. So my question is, I'm a chartered accountant myself, and my question is, does it make sense to do redevelopment where you have to buy total TDR from the market? I mean, as a member, what are you going to get? Because the TDR you have to pay, the builder will have to pay TDR. So what will benefit will be there for the existing members, because no additional FSI is coming?
How did you arrive that there is no additional FSI available in the
I went to MADA and I found out, because the land is very small, and there is already a building, 7-story building already constructed. So all FSI has been used. That I have checked up with MADA.
See, that is where you go wrong. First is you appoint an independent architect,
Okay.
get the feasibility report done, and then
Okay.
you jump to any conclusions. So first,
Okay.
if it is a MADA plot, right?
Yes.
So the development will happen in the name of the MADA, but there is a process where the land can be transferred in your society's name, or the deed of assignment is there for the 99 years, right?
Yes, 99-year lease it is.
99 years, yeah. So 99 years lease it is there. So how many years have been passed? 30, 40?
Hardly 20 years.
So in 20 years, why are you going for a redevelopment? The first question. Is it building in a dilapidated condition?
It is let me be frank with you. The members, they just want redevelopment without knowing the fact, and it's the same with the committee. So without it, it is not in dilapidated condition. You can repair it, but the committee is purposely not repairing it because they say they want redevelopment, and they'll say we'll
Fine.
buy TDR from the market. We'll buy TDR.
No, but
I say, are you?
who gave them the idea that they have to buy the TDR from the market? Was any professional advice taken,
Uh,
or it is
uh,
just a hearsay?
no, yeah, I would say hearsay because they don't even follow the bylaws of the society.
Okay.
I'm the only one fighting.
What's your good name?
Dikshit.
So you have to apply your intelligence and say that first thing we have to is to get the feasibility report done by an independent architect and then
Okay.
take a decision whether you have to, because 35% fungible FSI is anyway the government is bound to give you.
It's already
Right?
a 7-story building. The land
It doesn't matter if it is a 7-story building or a 4-story building or a 14-story building. First is you should have the feasibility report, and depending on the width of the road, your FSI will also be determined. It is not that you will not get any FSI. So where is this location is of this Mata?
It's in Pavai. It's in Pavai. It's a very small land. There is no playground, nothing. I was involved in the calculation of the land to building ratio, and
that is a separate thing. First thing is you obtain a feasibility report from an independent architect, and then you can take it forward. Till then, only on assumptions you cannot work out.
I agree with you, sir. I completely agree. No, okay. I assume the architect will give me the additional FSI. Okay, if I say
architect will not give you the additional FSI. He will work out the feasibility report that this is the existing members which they have consumed, and this is 35% FSI which they are going to get it, and what is the additional FSI the sale component will get. It will depend upon the potential of your plot, whether it is on a 18-feet road, 30-feet road, or 60-feet road. According to that, he will calculate the FSI. Right. So first thing is get your homework done. First is go for a feasibility report.
I agree. I agree with you. Just one assumption. Assume that the FSI that we get additional is negligible. Assume on a worst case scenario.
See, I don't go on assumption. I go on the practical figures. Until and unless if the feasibility report is not there in front of me, I will not comment anything on assumptions.
Then I agree. Okay. Now, do we need to do conveyance because MADA
there is no need. There is no need. You have a lease. Only thing is you will have to take a permission that we are going for a redevelopment. That is the secondary stage. First is understand the potential of your plot.
Okay, fine.
Then only you decide the second thing.
Okay, agree.
So when I'm wearing a shoes and socks, what I will do first is wear the socks first and then the shoes, right? I will not put the shoes first and then wear the socks. It doesn't happen that way. So the first thing is you will have to have the feasibility.
Yeah, I completely understand. Thank you very much, sir.
Welcome.
Thank you, ma'am.
Yeah. Sir, there are two questions. The amnesty scheme that has come up recently, and with regards to redevelopment, you have made a thrust, and I believe in that. So my question is, in this amnesty scheme, once the first particular stage of calculating the stamp duty is over, they will ask the registration. But a lot of old societies are there which are 30 to 40 years old, and in this particular cases, the seller or the builder who has developed this property, those are not traceable or not existing now. So in this case, is there any GR that is going to come, or are there any separate guidelines where who will be taking care about the registration part? Because a lot of files are stuck up. Because in your last session you had said, and I had attended that, you clearly mentioned that they will work out the stamp duty, and once the stamp duty ka challan is generated, we will have to pay. Once we pay, and if we don't get the registration done, then how will it proceed further?
No. Once if you pay the stamp duty, then what you want to register?
The document.
Which document?
So now these people do not have index 2. There is only one agreement which was executed, but
now once you pay the stamp duty and it is adjudicated,
uh,
right? So there is no question of registration now. Only thing is you will have to go for the conveyance. Either you go for a dim conveyance or consumer to conveyance to consumer court. There are two options. So that will take care of who will, if the builder is not existing, right? So they have an system where their registrar will appoint somebody from their office and who will come and sign on behalf of the builder, and your transaction of the land to the society will be executed. Next question. Sir, once you get your stamp duty adjudicated in the
uh,
amnesty scheme, the second step is to get the conveyance either through dim conveyance or through consumer court. They will issue an order, and if the builder is not traceable or he is not in on this earth, he has gone to the next world, then
uh,
they have a system policy is that the consumer court or the dim conveyance officer will appoint one officer from their organization who will come and sign that registration, the dim conveyance or the conveyance to consumer court on behalf of the builder. So if the
okay, sir.
builder is not there, then it is not a problem.
Okay, sir. Thank you. So the process is process of appointment of such officer would be done later on. So it is advisable that
Later on.
the
Either you
document.
go through consumer court or you go through dim conveyance.
Okay, and sir, in this case, if the customer asks that what would be the time frame for getting the document done in consumer court, what we would advise? Ki how much time it would
I
take
don't
usually?
advise. I am an advocate. I am not an astrologer who will say that it will happen in so and so time. It depends upon the advocate which you hire,
Any sir,
how
what?
efficient and resourceful he is.
Okay,
Okay.
ठीक है sir. Okay, thank you sir.
So my name is Anil here. I am actually an engineer and a lawyer also. I just finished my law also. I have a old society in Science, Surya Nivas. This is a three-story floor building. We actually are looking to go for redevelopment. So I had asked a question on chat about redevelopment. You said there are videos which you have posted. Are these available on LinkedIn or YouTube?
On YouTube.
YouTube. Okay. Second question is, sir, you've also spoken about architects to appoint an independent architect. I would like to do that, but do you have any references or anyone who I can approach, or should I just
Yeah,
Google and do it?
no, you can call me because it will not be advisable for me, to promote anyone. It will be like promoting anyone. You can call me,
Yeah,
DM
I
me
can do
first.
that. Okay. And one more thing is, can you just give me more information about conveyance deed because I've not been able to understand. And conveyance deed with respect to our own society, self redevelopment. What do you mean by conveyance deed, and how can I get this done for me to go to self redevelopment?
See, there are two ways. Actually, there are three ways, right, of doing
Okay.
this conveyance deed. One is the builder comes forward as per the MOFA section. He has to
Yeah.
transfer the land to the society. So that is
Okay.
one way he has not done.
Yeah.
Now, second is that you go by the dim conveyance.
Okay.
In conveyance, you have to go and fill up the form, submit everything. The builder will be called for the hearing after 6 months or 1 year. Then one order will be issued that the dim conveyance is granted, subject to
Okay.
paying the stamp duty. Then
Okay.
now the adjudication process starts, which is the most tedious and very tiring process, where all the documents of all the society members will be scrutinized and they will come out that this document is missing, this on this document so and so stamp duty is not paid.
Yeah.
So and then the people say that they have to give some speed money so that the process gets kick started. So that
Yeah.
takes very long time until because
Yeah.
all the members you have to from chain of documents has to be submitted, and it is a
Yeah.
very lengthy process.
Okay.
Third process which I normally prefer and promote is, or I'm in favor of, is to go through the consumer court for
Okay.
the deficiency of service and unfair trade practice by the builder. So once
Yeah.
the society goes with the
Yeah.
pecuniary jurisdiction keeping in mind, it will may go to district forum or it may go to state commission, or if it is above 2 crore, if you have paid more than 2 crore rupees, then it will go to the NCDRC in Delhi. So the
Okay.
hearing will take place. It takes around 2.5 years to 3 years or maybe 2 years. That time is consumed even in the dim convent also. But here
Okay.
you will be compensated for the deficiency of service, unfair trade practice, mental agony. All this will be calculated, and plus whatever the outgoings was supposed to be paid by the builder, because who is the owner of the land? The builder. So he has to pay. So you will get money for that also.
Okay. I also had one more thing that you spoke about property card. I checked the property card right now and it is on the society's name. So conveyance deed is applicable for this also.
No. So once if it is there in the society's name, that means the conveyance is already done.
Conveyance is already done. Okay, great.
So after getting the conveyance, the name in the property card changes. That is the stage after getting the conveyance. So that means your conveyance is done. So that's why the property card reflects the name of the society.
Yes,
so you
it,
just
it
have to
reflects
work
the
for
society.
it.
Yeah.
You
Okay,
just have
great.
to focus on self-redevelopment or redevelopment. Depending upon your first is find out the feasibility report.
Yeah. I will contact you for the architects after this. Yeah. Thank you so much.
I have to ask you that there is a joint family property more than the landlord's demand for redevelopment. Means they want more area than the landlord. So are there decisions, are there opinions are to be considered?
I didn't get you. It's a cooperative housing society or it is a tenanted building?
No. It's a private property where a building is there and it's a joint family property, ancestral property.
So it is within the family.
No, I didn't get you.
No. Is it a cooperative housing society?
No, it is not a society. It is a
So then
private.
what is your this thing there? Are you an owner or you are a tenant? What you are then?
Landlord.
You are a landlord.
Yes, and there are two tenants. So their demands are more. They want more area than the landlord. Means they want.
In redevelopment, tenants does not have any say. The G.S. Patel recent judgment gives that the tenants do not have any say in the redevelopment.
Okay, sir. And so one more question. In the same property, one of the landlord. There are 6 landlords total.
You are a landlord or you are a tenant?
I am a landlord. And one of the landlord is been handling. There are several cases, civil cases, and one of the landlord is handling the cases since last 20 to 25 years.
Which
And
cases?
the other
Which cases is handling?
civil cases, they want rent. The tenants want the rent to be decreased and all that, and the owners have filed for the eviction of them. So therefore, the other landlords, other 5 landlords are asking for the redevelopment. So is that possible, or they will keep this one landlord at the side and make the redevelopment?
Your question is totally off the topic. For that, you will need to have a consultation separately.
Okay, sir.
Yeah, bring on all the documents because this is not related to cooperative housing society.
Okay, sir.
You're related to, you are a landlord and there is a dispute among yourself and the tenants. So we'll have to study all the documents before giving you any opinion or any advice.
Okay, sir.
Okay.
Thank you.
Next question.
So can the redevelopment be just for pure profits or does it have to be in a dilapidated situation?
See, if the building is in dilapidated condition, you have no choice, right? If it is C1 category, then you will have to vacate the building and do the repair. And repairs are sometimes more costly than going for a redevelopment. So it will depend upon, it is not for more profit. It is getting a new building with all the amenities and bigger area. And the corpus fund and the rent is the byproduct of the redevelopment.
Yeah, but if the project hasn't lived many years.
So if it is 30 years old, then you can submit a structural audit report that the building is going to be dilapidated. Now it is in C2 category and it will go to C1 category if the repair is not done. So we want a redevelopment. So that criteria is there.
And below 30 years, 20 years building?
You will have to justify that why you want to go for it.
Just for the simple pure profits, the additional FSI, which is possible.
It is possible, but it depends upon whom you are going to engage.
Okay, so nothing bars the society from going for it, even if in case it is a young building.
Means you will have to justify that why you want to go for it. That justification has to be good enough for the officer to understand. Yes.
Okay, thank you, sir.
Yeah, sir, Aarti again. One more question I have.
Yeah.
Sir, once we vacate the plot, when the redevelopment, like in my father's building, they vacated the land and the society went in for the already there were cases on the committee before vacating for non-supply of documents and misappropriation of funds and all. Now it is 7 to 8. They are not getting the possession back, and the managing committee members have just disappeared. But God knows where they are. They've made the settlement with the builders. So then non-members क्या standing होती है जब managing वाले गायब हो जाते हैं या अपना सेटलमेंट कर लेते हैं या कुछ भी कर लेते हैं बिल्डर के साथ, और उनके ऊपर पहले से भी केसेस चल रहे होते हैं जो मेरी डैड की बिल्डिंग में हो रहा है सैंटा क्रूज में.
Now, what is the stage of the construction? Has the construction happened, or it is still the building is not demolished? What is the stage now?
Construction has happened, but no CC has been taken, and the leakage has also started immediately after the construction. And it's only 20 flats. Then too, this is the situation over there.
So you have a PEAA agreement with you?
Yeah. My dad has everything.
So then see, even as per the new construction, as per the MOFA, as per the RERA, if the new construction has any defects from the obtaining occupation certificate till 5 years, you have to approach the authorities and get it rectified. If he has all the documents PEAA, then he has to approach the appropriate court and take action against the builder and the managing committee.
नहीं सर, यही हो रहा है. क्या हो रहा है, कमेटी वालों ने अपना सेटलमेंट करके हट गए हैं और रेंट बिल्डर ने बंद कर दिया 5 साल से, और अब उसने ओसी भी नहीं दिया है, और ये सारे केसेस चल रहे हैं. तो पहले तो रेंट के इतने लाखों रुपए भर रहे हैं, प्लस केसेस के भर रहे हैं, और सारे मेंबर्स भी तितर बितर हो गए हैं. और कमेटी जिसने सारा प्रोसीजर इनिशिएट किया था उसकी तो कोई जिम्मेदारी नहीं रही और वो चलती बनी. दिस इज द सिचुएशन ओवर देयर. बिल्डर का भी कोई अता पता नहीं, क्योंकि आपको पता है कोर्ट में कितना टाइम लग रहा है. भले ही वो कंज्यूमर कोर्ट में गए हैं तो भी, एंड सारे पैसे वही भरे जा रहे हैं 5 साल से, रेंट से लेके केसेस से लेके सबके.
That's why if you watch my videos, I clearly says that development agreement and the PEAA agreement has to be made protecting, keeping in mind the interest of the existing members. If it is not done and it is done only for making profits by some hidden agenda of one or two of the committee members, then you are in a big soup. So it is better to have your own advocate appointed by the society to take care the interest of the existing members. So what you have to look for is the development agreement and PEAA agreement are a balanced terms and condition and not the one-sided terms which favors only the builder.
सर ये बिल्डिंग C1 डिक्लेयर करवा दी गई थी क्योंकि उसका रिपेयर नहीं किया था, इसलिए अर्जेंसी में सब काम करने पड़े.
Now, see, I'll tell you, the matter is pending in the court.
Yes, sir. But it is, and इसी के डर के मारे मैं रीडेवलपमेंट की कंसर्न नहीं दे रही, क्योंकि सिमिलर सिचुएशन इज लाइकली टू गेट रिपीटेड इन आवर सोसाइटी. The functioning which I'm seeing.
So no, it doesn't mean that if it has happened with the A, it is going to happen with the B also. With taking what has happened with your father, you have to safeguard your interest and say by this and these things should not happen and this clause should be changed or modified. So hire a professional advocate, take professional advice and do your development agreement and redevelopment. And before selecting the builder, just go and visit his past projects. Go physically and check. Have a word with the existing member and the sale component. How was their experience? If they say yes, it is good, and the builder has given us the possession on time or maybe 6 months date also, then also consider him as a good builder. But if his project is stalled for 8-10 years and is not paying the rent, not doing the construction, you cannot give your society to that builder. So that homework you have to do.
Okay, sir. Thank you for the guidance.
So, what are the career prospects for advocates in the area of redevelopment?
See, there's a lot of scope for the advocates in redevelopment scenario because every other building is going for a redevelopment. So either you become an advisor to the society, or there are going to be litigations which are going to come up because all the projects are not going to be completed on time. There will be some, mismatch or some mishandling by the builder. So there are going to be a lot of scope for the advocates who are looking for a career and opportunity in these areas of redevelopment.
Okay. Thank you so much, sir. With this, we come to the end of today's webinar.
Thanks.